All right, so I'm not doing my duty very well here because this train is now running a little bit late, but why don't we start our last panel? For those of you that were wondering, there is a reception that's taking place after this final panel. So, I and the lawyers / historians on this panel are between you and booze. So just, we apologize.
Not an enviable position to be in.
It is I think it's in the Rotunda room at the Washington Duke, and so you're invited to come and have a drink and continue the conversation of what I think has been an incredibly informative and engaging program so far, and really, really thankful that we have such splendid participants at this panel, and of course to Jake and Allison, who've done such a good job sort of putting this together. So I'll keep my introductions pretty short and let the panel speak for themselves. In order of their presentations, we've got Judge Campbell, who's an associate professor at the University of Richmond Law School. His academic focuses on constitutional history. He's published very well, Yale Law Journal, Stanford Law Review, Law and History Review, clerked for Judge Diane Sykes on the Seventh Circuit and for Jose Cabranes on the Second, and holds a bachelor's degree from the University of North Carolina at Chapel Hill. So he took all his meds before he came into Duke, I think, and 2 master's degrees from LSC, where he was a Marshall Scholar, and his JD from Stanford. Saul Cornell is going next after Professor Campbell. He's the Paul and Diane Guenther Chair of American History at Fordham University, and he also teaches in the law school. He's the author of 2 prize-winning works in American legal history, one on the nation's leading, and is one of the nation's leading authorities on the early American founding era and constitutional thought at that time. He's the author of A Well-Regulated Militia, The Founding Fathers and the Origins of Gun Control, and that and other work has been cited by legal scholars, historians, and by several courts, including the Supreme Court of the United States. Our last speaker is Professor Joyce Lee Malcolm, who's the Patrick Henry Professor of Constitutional Law and the Second Amendment. She's a historian and constitutional scholar active in the area of constitutional history, focusing on the development of individual rights in Great Britain and America. She's the author of 8, count them, 8 books. I wish I could sort of aspire to that kind of productivity. Most recently, The Tragedy of Benedict Arnold, An American Life, which was published in May of 2018. She also has written many books and articles on the Second Amendment and gun control, as well as individual rights, and was cited by the Supreme Court in the majority decisions in both Heller and in McDonald versus City of Chicago. And she has just been appointed and confirmed by the Senate to the National Council on the Humanities just this past August. Congratulations. And with that, we'll begin.
All right, thank you. So I come at this less as a historian of gun rights in particular and more as a historian of rights. And my general shtick is that in order to understand founding era debates about rights, and indeed debates about rights even through, say, 1950, you need to step back from thinking about freedom of expression or freedom of the right of religion or the right to keep and bear arms, and instead try to conceptualize how people thought about the concept of rights, and then also to think about how people thought about the enforcement of rights institutionally. How is it that we go about enforcing these things? And in both respects, there are fundamental differences in the ways that people 200 years ago thought about the concept of rights, even though there are at times very close similarities. And so the first step is to think about what is a right. And it turns out that there's not a single definition of a right at the founding. Instead, there is a discourse about rights that's grounded in the political philosophy that undergirded the entire constitutional world of the founding era, which is social contract theory. So social contract theory is something that's familiar to people who take political philosophy classes now. It's not very familiar for people who study the Supreme Court or constitutional doctrine, but 200 years ago, it was actually an essential part of constitutional discourse. And social contract theory posits that you start in a state of nature with natural rights, and then, and this is sort of a thought experiment, then you agree, each and every person agrees to leave the state of nature to form a political society, a body politic, also called the people themselves. And the people themselves then may choose to create a government or to delegate power to a monarch to better protect their natural rights. Now, natural rights under this theory are something that can be and should be regulated in promotion of the public good. So when the people come together to better protect their right to freedom of religion, right to move, the liberty of locomotion, right to liberty itself, right to property, and so on, there is an understanding that those rights can be regulated in promotion of the public good. And we see the promotion of the public good defined primarily in opposition to the promotion of or pursuit of private interests. So the government is not allowed to pursue its own interests at the expense of the people. The king is not allowed to pursue the interests of his friends or himself at the expense of the public welfare. At the same time, there's a concept of rights that I call fundamental positive rights that operate as specific restrictions on governmental power. And so these are rights that are actually defined not in terms of human capacities in a state of nature, right to move, right to speak, right to think, and so on, but instead are defined in terms of a particular aspect of governmental authority. So the right to a jury trial is a positive right because it's defined in reference to government. It's a government, the jury is a governmental institution, and so that is what we would call a positive right. Right to habeas corpus, right to confront witnesses, right to due process, and so on are positive rights because they're things that are specifically limiting governmental power or obligations on the government in reference to the way it acts towards citizens. Now, we have a concept of natural rights that clearly covers certain things that are contained within the First and Second Amendments. So speaking, thinking, praying, worshiping, owning a weapon, carrying a weapon, those are all things that are easily identified as natural rights. They're human capacities that aren't the creation of government. They aren't themselves a governmental institution. And so those are types of rights that we can identify as natural rights, and those rights in general would then be regulable in promotion of the public good. But there's an understanding that certain types of governmental regulations of those rights would not be in promotion of the public good. How do we figure out what those types of governmental regulations are? In the English experience, the way we figure those dimensions of governmental power that are outside of the scope of governmental authority is through custom. We have a set of political settlements throughout English history, particularly focused on the 17th and 18th centuries, that settle certain aspects of debates over what the scope of governmental authority should be with respect to, say, regulating speech or regulating religion or regulating the right to keep and bear arms. And so what this means is that you have not a unimodal concept of rights, but actually a bimodal concept of rights. And you've got to be really careful when you're looking at the sources, because the sources sometimes will be talking about rights in this sort of broad, general sense of natural rights. It covers nearly everything, but the degree of protection that it offers is very thin. And it's the type of thing that is determined, the scope of governmental power with respect to these natural rights is determined by public policy debates about what types of restrictions of liberty and property would or would not promote the public good. And at the same time, we have this discourse about particular settlements that are reached throughout history about the, let's say, right to speech includes the ability to speak without government punishing you for criticizing the government in good faith. Or the right of freedom of the press includes a strong protection against being forced to get prior permission of the government before publishing what you want to say. Or, as relates to the Second Amendment, we have a set of English debates about the right to keep and bear arms that then would inform what it is that the right to keep and bear arms entails with respect to governmental authority. And so that's what you're going to hear a lot more about from Saul and Joyce, is what is this English experience? How do we define what the tradition is? And that type of debate, when it has a certain degree of settlement, the principle against prior restraints, the rule that the government can't punish you for good faith criticism of the government, those types of political settlements operate as sort of determinate legal rules in some respect. But then they're also a source for further argumentation. And so the way that this plays out at the founding is that you have a general right to speak. That right can be regulated in promotion of the public good. We know that certain aspects of regulation are beyond the scope of governmental power because we have the customary tradition of protecting against prior restraints, protecting well-intentioned public debate, and so on. And then, if there's a further governmental power that is exercised in a way that people believe to be contrary to the public good, we can then have a public debate about whether that type of exercise of governmental power is consistent with or in derogation of the freedom of expression. And we can draw on the tradition and try to have arguments about what the tradition entails when we're making those arguments, but those are arguments that are fundamentally political. And so what you would have then at the founding is some aspects of protection for natural rights that are judicially enforceable, namely those aspects that are well settled through custom. And then you would also have the capacity to engage in a broader discourse about extending protection for certain types of, against certain types of governmental action that would not be judicially enforceable, but instead would be decided through political discourse. Now, the problem that you get into in the 19th century cases on concealed carry is that what we have in the 19th century is two things that are developing at the same time. So the first is the emergence of a new problem that creates a new legislative response. The new problem being escalating violence by use of various weapons, Bowie knives, handguns, and so on. And then secondly, you have the emergence of a legislative response, which is to restrict for the first time the concealed carry of various types of weapons. All right. At the same time, in the early 19th century, you see judges becoming increasingly self-confident about their role as the enforcers or guardians of constitutional limits on legislative power. And so what that means is that judges then start to increasingly step in and try to enforce limits not only that have been specifically decided through customary tradition, but also to articulate in more general terms what it is that the legislature is or is not allowed to do. And so what we start to see in the 19th century is a jurisprudence of the police powers. What sort of uses of general legislative power to promote the public good can legislatures act on, and which ones are outside the boundaries of their ability to pursue the public good? And so the problem that you're going to see in these early 19th century cases is the way that existing doctrine tells you to respond to new problems is not delineated by tradition, because the problems themselves are new, and therefore there is no tradition to clearly tell you what it is you're supposed to do or not supposed to do. The way that you would originally have responded to that type of situation is to have an open debate about what the tradition means, and a debate about what sorts of powers would be in promotion of the public good or not in promotion of the public good. Judges, though, have role limitations that prevent them from doing that sort of general interest balancing type analysis. Judges are not inclined to have debates about what the sort of abstract meaning of a particular tradition is, and so judges start to articulate limits on legislative power in more legalistic terms, in more formalist terms. And so what we see in the early 19th century debates over concealed carry is a mixture of responses to this dilemma, which is, how do we articulate limits on legislative power while also acting in accord with limitations on the judicial role that prevent us from doing the type of general interest balancing that customary constitutional traditions would suggest. And so these early cases are, I think, really nice illustrations of the sort of central dilemma of rights jurisprudence for the next 200 years, which is, how is it that we create legal doctrines to implement a general sort of political philosophical principle that governmental power should be only in promotion of the public good or not in promotion of the public good? And so this is what I think gives rise to the problem that Greg, for instance, was talking about on the first panel of conflicting interests. And the response that judges typically give for the first several hundred years is either to say this is just a question of legislative judgment, and that is generally the approach that judges take in nearly every case for the first 150 years in police powers jurisprudence. Or they articulate some more legalistic restriction on the way that the legislature can use its power. So this is the same type of doctrinal development that gives rise to, say, the business is affected by a public interest or not in the Lochner era period. What we see the court do in the 1940s and 50s is engage in a more realistic jurisprudence, a jurisprudence that acknowledges the real interests on both sides of the equation, and the court's engaged in that period in an effort to more carefully evaluate what those interests are from a realistic standpoint rather than this sort of false legalistic standpoint. And I think that the court in the 60s and 70s really starts to shift away from that sort of balancing approach and returning to a more legalistic approach to evaluating rights, but one that's no longer as deferential to governmental power, in particular in areas involving freedom of religion and freedom of speech. And so what we see in Heller is really an extension of that approach to evaluating enumerated rights, an approach that now has sort of merged the two strands of rights jurisprudence that we saw at the founding, an approach that takes general natural rights, any governmental restriction of freedom of expression, or any governmental restriction of the right to carry or possess a weapon, turns it into then a legal question, a question of legal doctrine in a way that just would not have happened at the founding, because at the founding, these questions are fundamentally political. To say, I have a right to carry weapons outside the house at the founding is a perfectly permissible argument. That is well within the boundaries of founding era rights discourse. But the core question then is, what is the countervailing policy interest that might justify the government's ability to regulate that? Would that countervailing policy interest in the aggregate be used in a way that subverts the public good more often than it aids the public good? If so, I have a political argument against governmental power to exercise this type of restriction. But what I've done now is not to make a legal argument to a judge, but rather to engage in a political argument to the body politic about what its constitution is. That's exactly what Madison and Jefferson are doing in response to the Sedition Act. They're not making a legalistic argument to a set of judges about the meaning of rights. They're articulating limits on governmental power to pursue the public good based on a set of policy arguments about what sort of exercises of governmental power are more dangerous than others, and using that sort of broad discourse to try to define a new tradition in exactly the way that English customary constitutionalism would entail. And so I'm very skeptical of using history to provide specific answers to questions that weren't debated at the founding for exactly this reason. We would have open public debate at the founding about what the traditions mean and about what sort of powers would or wouldn't be conducive of promotion of the public good, not a sort of modern, legalistic, post-1970s doctrinal approach to these sorts of questions. So I think I'll stop there.
Thank you. Saul?
Do I have to do anything to cue the screen?
Ah. You point to the sky.
So while the screen is descending, dramatically I might add, I want to add my thank you to the Duke Firearms Law Center and to Jake and Allison and Joe and Darrell, because they really have done something quite remarkable down here. When I first got into this debate too many years ago to actually give you a specific, I sort of wandered into this debate quite by accident. Most people who get into this debate have a strong feeling about firearms. I was like, firearms, schmeierarms, I was interested in this debate because I saw history being abused. And it's a bit like that episode from Seinfeld where Jerry's dentist, converts to Judaism because he's tired of being the butt of the jokes and he wants to tell the jokes. And at the very end, Jerry goes into a confessional and explains this to the priest. And the priest says, "And my son, you're offended by this as a Jew?" And he says, "No, I'm offended as a comedian." And that's sort of always been my problem, that most of the people I deal with in this debate always think it's about guns, but for me, it's always been about the history. So with that note, what I want to try to do is talk about how history has been much abused and to sort of go through some very specific claims that have been made that I think are erroneous. But the point is not to make a kind of guild argument. My point is not that you have to be a historian. My friend Judd is one of the best constitutional historians of his generation, and every time I read something by him, I just marvel at how good it is. And the charge of law office history, which I've made on many occasions, is not something that is exclusive to lawyers. I think historians do it all the time as well. It's very tempting, and it's part of the problem of confirmation bias, which we all know is something we all have to be on guard. So I've started out here by sketching what I think are the emerging, based on the best scholarship out there, what I'll call the historical paradigm, and I've given you Cleo, the muse of history there, and another paradigm, which I think is ultimately not historical but ideological, and it's libertarian. And some of you are probably thinking, that's not fair. You have a beautiful picture of Cleo, and you have that picture of Ayn Rand. Why couldn't you find a flattering picture? In fact, that is a flattering picture. I think political scientists year in and year out have voted her the ugliest political thinker of the 20th century, not to be lookist, but she has been described as the gateway drug for young conservatives. So with that, the question is, what did liberty mean? What did the right to bear arms mean? What were the limits? And which of these models makes more sense? So I don't want to get into, I was at a conference where there was a Canadian legal scholar who basically said, I can't believe you're talking about the Statute of Northampton in terms of modern gun policy. What kind of crazy country do you live in? I said, America. He said, oh, that's right, originalism. And the one point, and I'll return to the Statute of Northampton, is that most people who try to dismiss the importance of it, and believe me, if I had my druthers, I actually was going to issue a trigger warning talking about safe spaces, because I have been known to be very triggering for originalists. So if there are any originalists in the audience and you're feeling triggered, you're actually feeling what I intend to convey to you. If I had my druthers, I wouldn't be talking about statutes from Edward III, but this is what the world that Scalia has given us. And basically, if you read Eugene Volokh or David Capel or my colleague Nick Johnson's textbook, they'll say that the only limit on traveling armed is if you traveled in a fray of the peace. But if you actually read the statute, it's very clear that bringing force in a fray of the peace is separate from riding armed by day or night in fairs or markets. It's just a different part of the statute. So, far be it from me, a historian, to lecture lawyers on modes of statutory construction, but the text is the text. All right, so, oh, sorry, I blanked that out, didn't mean to do that. All right, so unfortunately, and I suppose this will make for some interesting sport for the rest of the afternoon, I'm going to talk a lot about Joyce, because Joyce's work is really central to this libertarian paradigm. And I think at this point, it's very clear that she's just wrong about almost everything. And most English historians think she's wrong about everything, but I don't want to make this an argument from authority. I want to just show you the evidence, and I just want to see what Joyce has to say. So in a recent article in a book, a great book, by the way, on the right to bear arms, she says, Pollock and Maitland, who are authors of one of the great treatises on English law, don't even mention the Statute of Northampton, presumably concluding it was not important. Well, I'll suggest that, oops, sorry, I didn't mean to do that. Well, of course, the treatise goes to the reign of Edward I, and the Statute of Northampton is from the reign of Edward III. So I would suggest there's an alternative explanation about why I don't talk about it, because it hadn't been enacted by the time the book ends. So, in terms of trying to dismiss the Statute of Northampton, we got to get the chronology right. And, one of the first commandments to anyone who's doing history is to get the chronology right. And I think there's some serious chronological problems with Joyce's argument, this being one of them. And essentially, Joyce makes several claims that I think are wrong. She says the Statute of Northampton was rarely enforced, and it was an emergency measure. It only related to a fray or brandishing or actual assault. And because there was an obligation to assist in preserving the peace, that the idea that you couldn't travel armed would somehow violate this other English principle. So what I want to do is show you why each of these things is wrong. So first of all, the statute was reenacted on several occasions, which suggests that it was irrelevant and a temporary measure is just plain wrong. Every Justice of the Peace manual between Lombard and Dalton, who are the two great compilers of English law for a sort of broad audience, most importantly, Justice of the Peace, extensively discuss the limits on armed travel. So they would obviously not keep on discussing it if it was irrelevant. The reading of the text, which Joyce offers, and Volokh and Capel, the whole, Second Amendment mafia, if you will, is just not consistent with the text. The text clearly separates out a fray from a separate violation, which is traveling by day or night in fairs or markets. Also, it's a fundamental problem both of logic and law to always go to the exception to the rule to prove the rule. And if you look at Joyce's evidence, it's almost always a recognized exception to the rule, which she takes to be the actual rule itself. So she says here, banning people from riding armed would have thwarted the militia requirement along with the obligation to be armed for self-defense. That's not what Dalton said. If you look at Dalton, he said, no person may carry in his journey any gun, dagger, or pistol, charge or bow bent, but only in time of service of war. Secondly, he notes that traveling armed in pursuit of the hue and cry or in the assistance of preserving the king's peace is perfectly acceptable. It's an exception to the prohibition on the Statute of Northampton. And then further underscoring the point, it says that even if you have to do that, 'tis most discreet to be assistant to some ministerial office in this matter. So even if you're going to do that, you'd be well advised to do it only when summoned by a JP or only in conjunction with a representative of the king's peace. All of this just makes this claim, I think, false. I mean, there's no way to reconcile that claim with this evidence. If we actually look carefully at the expositions of the statute, shall go ride or armed defensively or with an unusual manner of servants or attendants. Those are two ways. Those are per se the crime that disturbs the peace of the people. It's important to realize we're in a time where the king's peace implies a monopoly of violence. Anything which causes a disturbance is a violation of the king's peace. And even to presume to carry a weapon outside of the recognized exceptions, if you're not legally authorized, is to in fact say that the king is not doing his job. I need to arm myself. Under traditional theories of English law and monarchy, that is a rebuke of the king's majesty. That's a crime. And you'll notice also that the crime of brandishing, drawing a weapon, or striking or assaulting or breaking the peace is separate from the separate crime of riding armed defensively, which is the terror to the king's peace. So all of this evidence is, I think, impossible to reconcile with the sort of right of peaceable carry that Joyce and David Capel and Eugene Volokh have all posited, which is just not true. The evidence just does not support it. Sorry, that's my cheesy PowerPoint effect. I'm one of the few people in the room who has to teach undergraduates, graduates, and law students. And believe me, going up in front of 300 hormonally enraged undergraduates without a PowerPoint slide is probably more dangerous than going into some of my old neighborhoods in Brooklyn, which probably I can't afford to live in anymore. But that's another subject. And then, of course, there's the fact that a number of leading English historians have basically argued that Joyce's account is just wrong. And perhaps the most recent and most significant is Tim Harris, who's one of the leading authorities on the Glorious Revolution. And as Harris says in this book that Joyce and I both have an article in, the Glorious Revolution has been extensively studied and debated ever since it occurred. And until Joyce's work, no historian had ever sought to argue that one of its most significant accomplishments was to establish a right to bear arms for Protestants. In fact, Harris goes on in another place to say, the proper reading is the English provision actually reasserts the right of Parliament to regulate firearms, and it limits it by both religion and class, which is hardly, a strong foundation for an individual right. Okay, how am I doing on time? 3 minutes. Here is a Justice of the Peace manual from early 18th century America, right before the American Revolution. As you'll note that the description of the principle embodied in the Statute of Northampton says that any person who shall go ride or armed with unusual and offensive weapons in an affray or among any great concourse of people is a violation of the principle. So again, we're not talking about just affray. We're not just talking about assault. We're talking about a separate crime, riding armed in contravention of the king's peace. Now, if I had more time, I could take you through the story further to show you how this English tradition fragments. And one of the big problems about Second Amendment scholarship is that it's cut off, it's siloed off from other fields in both the history of criminal law and the history of American legal history. Virtually all of American legal history at this moment acknowledges that there's tremendous regional variation and that English common law splinters and fragments into different kinds of common law cultures in, for instance, the slave South and the North. Yet if you read Second Amendment scholarship by guns rights oriented people and libertarians, it's always this monolithic tradition that's fairly unchanging. Well, nothing is unchanging in early American legal history, and nothing is monolithic. So at a very minimum, they accounted for diversity. So I'll just end with one point that sort of picks up on Judd's point. If you look at Heller, it's funny that all the case law is Southern. You have to watch out for Nino. He's kind of always tricky bugger he is. And so the great question is, what was happening in the rest of America? And at the point that Heller was decided, we didn't have a lot of history. It was a big silence. But we now know there was a separate regulatory tradition outside of the South, and that regulatory tradition was much more restrictive about public carry. So I think if we're going to move forward in this, we have to be a lot more rigorous about the sources. We have to avoid some of these claims that are now demonstrably false, and we need to recognize the diversity of the American experience. Ultimately, this may be a good thing, because maybe this will bring us back to federalism, which may be the only way to deal with the gun debate, given the radically different regional gun cultures in America. So on that note, I've returned to my anti-federalist roots, and I look forward to Joyce's response and your questions. Thank you.
Mr. Malcolm.
I never realized I was part of a mafia. Usually historians get to go first because we're doing history, and being a woman, I usually get to go first of the first. Now I get the last word, and I'm really pleased I do, because I did not expect that Saul Cornell's essay would be completely against me. I'm here actually not just against him, although I do have one quotation from him. But we're supposed to be looking at the right to carry a gun outside the home, and that's what I'm going to be focusing on. My issue is, why are we still talking about this? We have had two major Supreme Court cases, one in 2008, one in 2010, very serious analysis of the history. And in fact, I think the history was really terribly important, because until the 1970s and 80s, there had not been a lot of historical research into it. Part of it was that people just kind of assumed from the founding that they had a right, as it says in the amendment, to keep and bear arms. At any rate, these two decisions found, one, that the core of the Second Amendment was the individual's right of self-defense. And I think that is why, and some of the other talks that you've heard, people are so passionate about not willing to have their weapons taken from them and to have to be victims. It's sad, but there is a lot of violence in this country, and people feel much more confident if they know they can protect themselves, particularly women and the elderly are able to protect themselves. The court said that the right to keep and bear, you have a right to keep and bear those weapons in common use for self-defense and other lawful purposes. In McDonald, which incorporated the right to self-defense for the nation, they had to decide whether it was fundamental to our scheme of ordered liberty and system of justice, and that was what Alito found, that it was fundamental to our scheme of ordered liberty and system of justice. After all of that, I must say I do wonder why we have to still be arguing it. Part of the reason, I think, is that both the Washington ban on residents having a handgun in their home, and by the way, in which you could not bear the gun from one room to another within your home, nor could you put it together, it had to be kept as assembled, nor could you put it together in a case of an intruder coming into your home. So it was really kind of a blanket ban unless you happened to have the gun before 1976. But both the Washington ban and the Chicago ban were bans on having a gun in the home. And so even though the court went to great lengths to explain every word in the Second Amendment, the move has been to say, okay, well, we'll give up. You can have a gun in your home, but you can't take it anywhere else. So Chicago, their gun law having been overturned, decided you couldn't take it out to your porch. You couldn't take it to your garage, in your home, and that was it. But if the core is self-defense, self-defense is just as important outside of your home as inside of your home, and that was what the court had decided. Here's Justice Thomas on it. He said, I find it extremely improbable that the framers understood the Second Amendment to protect little more than carrying a gun from the bedroom to the kitchen. I mean, if you're talking about bear, obviously it has to be outside of the home as well as inside. Now we get to Saul. Saul Cornell is an expert at kind of picking and choosing what he wants from history, which is not exactly what we're supposed to be doing. But at any rate, here he is saying there was no traditional right of peaceable armed travel under Anglo-American law. So that's what I want to briefly look at. Deep history, I guess. But we'll look quickly at the English background and the American use, and then back to the Supreme Court. The English people were expected to not only, in a hue and cry, follow the sheriff to chase culprits, they were obliged to protect themselves. That was how you were keeping the king's peace. You had a duty to defend yourself, your family, and your neighbors. They took turns standing watch at night and ward during the day. They stood watch on highways to keep the peace. In order to do that, you had to be able to appear ready apparelled. So it wasn't just that they were only allowed to follow the local sheriff, but they really had local duties to help keep the king's peace. Now, the Statue of Northampton, which has been resurrected, I should say, by people who like to believe that there is no right to peaceably carry a gun, 700 years old. It was passed during a period of dynastic turbulence and actually plague. But as you've seen before, it forbids anybody but the king's servants coming into his presence or that of his justices or other ministers doing their office with force and arms, nor bring no force in the fray of the peace, nor go no armed in fairs, markets, nor in no place elsewhere. The issue is a fray of the peace. And it's almost never do you see a case in which it's just somebody going along with a weapon. It's obviously a measure to make sure that no one is out there with a gun brandishing it to terrorize people, which makes perfect sense. And some of the similar acts have been passed or reasserted in America with that same idea that you can't go carrying a gun to terrorize your neighbors or anybody else. Now, just one example of how this was used in England. This is the case of Sir John Knight of Bristol. And I have to give you a little bit of background. This was in 1686, before the English right, however imperfect it was, from the English Bill of Rights to have weapons, that the people had a right to have arms. The king at that time was James II, who had converted to Catholicism. And for Catholics, in the audience, I should say, it wasn't mere bigotry that the Catholics were under various liabilities. It was that ever since the English Reformation, the Pope had called upon Catholics in England to overthrow the Protestant monarchy. So there was still these concerns about Catholics. Even though the king was a Catholic, there were a lot of laws against what Catholics could do. Now, Sir John Knight was on the council in Bristol, and he was an ardent Protestant, keen to enforce all those laws against Catholics. But the king didn't know quite how to get at him because, after all, he was trying to enforce the law. So the king's council told the people in Bristol, that the government there, that he needed to be charged with wrongful use of a firearm because he was creating and encouraging fears in the hearts of His Majesty's subjects. He was a busy actor in trying to enforce these anti-Catholic laws, and he had actually taken his gun into a Catholic service while the people were there. And so he was being charged with encouraging fears, it's not just carrying it. What happened? Well, the Chief Justice, after hearing this, said, though the statute, this is the statute of Northampton, be almost gone in desuetude. Almost nobody used it anymore, and this was in 1686. I mean, it was hundreds of years old by that time. He said, yet where the crime shall appear to be with evil intent, it will come within the act, though there be a general connivance of gentlemen to ride armed for their security. So basically, even though he was riding armed and carrying his gun around, they were not able to get him on this because the jury decided that he had not actually put people in fear. He had gone into this Catholic service, but he hadn't arrested anybody, hadn't done anything with it. And the king failed in his attempt to try to sort of disarm political opponents or people who were busy actors enforcing laws that he didn't like with this Statute of Northampton. Now, shortly after James II was deposed, as it were, he fled, and we have the Glorious Revolution in England. It's glorious because it was a bloodless revolution, and as a result of it, the English Parliament, or the Convention Parliament, and then the Parliament that followed, passed a list of rights which were to reassert rights that they felt that James II had failed to follow or had actually violated. And they claimed that all of these were ancient and indubitable rights. Some of them were not ancient and indubitable. They were trying to kind of shove into this Bill of Rights things that were problematic, but they wanted to see in there. And one of them was this right to be armed. It wasn't an ancient right, really. I had tried to track it down. It was a duty. People had a duty to be armed, but they didn't have a right. And this is the language of that forerunner of our Second Amendment. It's a century before our Bill of Rights, that the subjects which are Protestant, who were about 90% of the population, may have arms for their defense, suitable to their condition and as allowed by law. And Saul was right. This is sort of problematic. What do we mean by suitable to their condition? It means their social status. If they were wealthy, they could have lots of weapons. That was not a worry. If you visit any of these wonderful castles in the Highlands of Scotland, they have wonderful decorations of muskets in all directions decorating their halls. But if you were a poor person amassing weapons, there was some idea that maybe you had something else in mind. So there was this suitable to their condition, and as allowed by law, obviously left the way open for controlling it. So what's important is, how did this work out after it was passed? What did they mean? Well, there were two streams, and I'm going to go through these because I don't know how much history you can bear before you get to your drinks. However, there were a series of game acts that were passed starting in the 17th century. And one of them in 1671, among the other things that you weren't allowed to have in order to hunt, because hunting was a privilege of the wealthy, was guns. For the first time, a gun was put on this list in 1671, along with hunting dogs and nets and other things. And this was not enforced by the general courts. It was enforced by gamekeepers, and so it was kind of not really very well enforced. After the Bill of Rights, the English Bill of Rights, guns were omitted from all of the future game acts. And there was a case that came up in 1739. You have to realize that it took a long time for the justices and others to actually know what changes had been going on. So some of these guidebooks for justices of the peace were plagiarized or copied over and over again with only slight changes made in the new edition. So there was a case in 1739, Rex versus Gardner, about the wrongful use of a gun. Somebody had a gun and someone else took him to court for it. And the court decided that a gun is not mentioned in this statute, 1706, and though there may be many things for which the bare keeping of which a man may be convicted, yet they are only such as can only be used for the destruction of game, whereas a gun is necessary for defense of a house or for a farmer to shoot crows. You do not shoot crows inside your house. I hope not. So, I mean, that was the way they saw it, that you needed a gun. It was absolutely necessary defense of a house or for shooting crows and varmints. A much later case came up, and at this point, the court was just astonished anyone should bring it up. It is not to be imagined it was the intention of the legislature in making this Game Act 5 and 14 to disarm all the people of England. So after that, what seems like a problematic right, the courts and Englishmen were really serious about making sure people could have weapons. Now, William Blackstone wrote his classic book on the Commentaries on the Laws of England, great bestseller on this side of the Atlantic as well as in England, and 10 years before our revolution. And he goes through all of the rights that Englishmen have. He talks about self-defense. It's justly called the primary law of nature. It's not just another one of those rights. This is your key right because the law cannot be there every time you need protection. And by the time it gets there, it's picking up the pieces. So basically, people need to be able to protect themselves. Primary law. So it is neither can it be, in fact, taken away by the law of society. And I think that's why people don't want to give up some way of protecting themselves. It's really very, very basic. And then he says that this right in the English Bill of Rights is for self-preservation and defense. So it has these two aspects, as our Second Amendment does, your personal self-preservation and defense in case the other rights are taken away. And that's how Blackstone sees it. Okay, now, a couple of other interpretations of what that right to be armed meant in England. In 1785, the Recorder of London, who was the legal counsel for the City of London, was asked about the right of subjects to carry weapons and carry weapons to assemblies and so forth. And he says the right of His Majesty's Protestant subjects, this was a few years before all of the liabilities against Catholics were taken away, to have arms for their own defense and to use them for lawful purposes is most clear and undeniable. And then he goes on the right that every Protestant most unquestionably possesses individually may, in many cases, clearly must be exercised collectively. And then there's one more bit of English history that I'm going to impose on you. But I think this is very clear, that it's true that that English Bill of Right about arms is very problematic in the way it's worded. But we have a case in which the judge goes right to the heart of it. Reed Dewhurst was about an assembly of people who were protesting an earlier violent massacre of peaceful protesters called I've forgotten the name of it. I'm blanking on it. Yeah, the Peterloo Massacre. Thank you very much, Peter. You know your English history. Thank you. The Peterloo Massacre. So that was terrible because this group of protesters who were against the what they felt was the unfair representation in Parliament and the Bread Acts was protesting, and they did not disperse when asked, and so they were actually fired on. So this other group protested against what happened to these people, the massacre. And the leaders were brought before the court. And the judge in this, Judge Bailey, asks these questions about how you interpret that English right. He says, whether it was the ordinary individual who had a right to bear arms and whether they had a right to carry them. And he said, a man has a clear right to arms to protect himself in his house. A man has a clear right to protect himself when he is going singly or in a small party upon the road where he is traveling or going for the ordinary course purposes of business. Now, somehow this has escaped Cornell's.
1820.
It is 1820, but it is a help in trying to understand exactly what was happening in the years around the time that that Americans at the founding were crafting their own constitution and rights. So it's a way of understanding what was happening in the English right. And I should say in America, obviously, every single colony had in its charter a guarantee that the residents would have the same rights as Englishmen. The same rights as Englishmen, they and their children as if born and abiding in England. And this was clearly one of the rights of Englishmen. Now, a lot of the English tradition was brought over here, the right that you had people who were to be armed to protect themselves and their families, to protect their community. There were actually, and I didn't want to list all these because we can't be here forever, and we want to, but there were laws about how everybody, all householders had to provide people in their Virginia towns with weapons, everybody capable of bearing arms, and to be ready. And there were some in which they had to travel with those weapons. And the Virginia Act excluded slaves, which was one of the first American acts that sort of set our rules about slavery. But in other states or other colonies at that time, that was not the case. But at any rate, that people were actually required to have weapons, and sometimes, in fact, to take them to church. They were also required sometimes to travel with them. Now, I don't want to go into the whole history of the Second Amendment and the drafting. I'm sure most of you are aware of the language of it. I hope that you're aware of the background and the debates. I mean, Madison referred to all of these amendments as guards for private rights. The Senate rejected the possible amendment after to keep and bear arms. The suggestion that it had for the common defense, they voted that down. So basically, it was meant to be an individual right, and all of the history and discussion of it was used by the Supreme Court in those two court cases. But these are, this is from the Philadelphia Federal Gazette and Evening Post shortly after the Bill of Rights was drafted, but before it was ratified. And so they were explaining to the people what was in these and what it meant. And this particular article got reprinted in New York and in Boston. And it really mirrors what Blackstone was saying. He was one of the most cited authors by our founders, second only to Montesquieu. And this is the way he interpreted it, or the article did. As civil rulers not having their duty to the people duly before them may attempt to tyrannize, and as the military forces which must be occasionally raised to defend our country might pervert their power to the injury of their fellow citizens, the people are confirmed in their right to keep and bear their private weapons, not the state's weapons as a part of a militia, their private weapons. And now I'm going to conclude with one of your heroines, Ruth Bader Ginsburg. Now, in writing the majority opinion for Heller, Scalia could not resist putting in a comment of Ginsburg's from an earlier case, Muscarella, in which she defined what bear meant. And this is what she defined what bear meant. A most familiar meaning is, as the Constitution's Second Amendment indicates, bear, wear, or carry upon the person, or in the clothing, or in a pocket, for the purposes of being armed and ready for offensive or defensive action in a case of conflict with another person. What I love is that, of course, Ruth changed her mind. When it came to Heller, she voted on the other side, that there wasn't, that it wasn't a right to actually carry it. But Scalia kind of, I don't turn the knife in, but he actually used her quotation to explain what she meant earlier on when it didn't include the Second Amendment, was just talking about the word bear. Okay, I guess that's all I have to say on it at the moment. I don't want us to go on forever, and you need to have some time to ask questions. I don't think that I've been unfair to the history. I'm a historian, that's my job. It is something I'm very proud of. I've never, except for Cornell, been accused of picking and choosing. He likes to talk about law office history, so all you lawyers should be careful, right? But there's a friend of mine who has talked about history office law, which also tends to be the idea that you pick and choose. I think that the worry about law office history is that lawyers, and it's understandable, start with a particular case that they're trying to make and then pick things that support their case, whereas historians are supposed to sort of look at the context and see what it's telling them. And I think that's what I have done and others have done. So thank you very much. I appreciate the opportunity to be here.
All right, so I just wanted to be noted that this is the only panel I've ever been on where the historians are more combative than the lawyers. So let me, so in the sense of like trying to preserve the peace, right? One way of sort of looking at these papers is that what we have is we have sort of two poles with what Professor Cornell has offered and what Professor Malcolm has offered. And I see Professor Campbell sort of in the middle, right? So there's a premise here that there might be some sort of right to firearms in the home, but in terms of public carry, there's some sort of public regarding or some sort of public purpose aspect to it. I think I'm hearing a thread within the papers that's correct. And it's also a point of political contestation. That is, the founding era would have seen public carry as something that was a matter of natural rights, but organized around some principle of for the public good. And how we think of it, whether we think of it as a public good in terms of a public duty, or we think of it as a public restraint, is the axes of division between our historians. And I'm just wondering what you think about that, to the panelists, if I'm misunderstanding the relationship between these arguments or not. So I'll open up to the panel for that.
I think that's right, that it would have played out as a matter of political contest at the founding had they enacted a concealed carry ban. It's plausible that the debate would have come out in favor of the folks who opposed the ban for the simple reason that there was, at the founding, not a particularly good reason to enact a concealed carry ban. And so social expectations and general public policy considerations could well have led to a resolution of that debate in favor of the right. The point that I'm making is that viewing the right in that sort of narrow way, I think, undersells the complexity of founding era rights discourse in a really profound way. And I would also say that I'm reluctant to embrace a notion of what the Second Amendment means in this sort of modern, heavily positivist and textualist way that we tend to argue about these things. At the founding, the conception of rights being written down was much thinner. The idea was we have the rights. They're actually guaranteed in the social contract. To a large extent, guaranteed through custom and tradition, through the people's recognition of their fundamentality. And we write them down to help preserve their longevity, to help encourage people to learn what they are, and potentially, insofar as they're legally enforceable, help encourage judges to actually stand up and do their duty to enforce them. And so I see the enumeration project less as sort of specifying the full range of governmental power in every respect, and more as of a piece with a long tradition of American and English customary constitutionalism.
Yeah, I think Madison wanted in his list of rights, and they ended up his list because there had been a lot of suggestions of possible amendments from other states, to pick on things that were not going to be controversial, that would easily pass. And I think there was just such a general feeling that people had this right to self-defense and to be able to protect themselves and requirements that they protect each other, that it was not controversial. What would have been not controversial is your suggestion about concealed carry, because they believed that the only people that carry concealed were villains or people that wanted to rob you, Whereas open carry was what honest people did. And for some reason, and you may know when that switched, or someone may, we now feel better not seeing that. But in the past, it was just the opposite, that they felt that concealed carry was for people who were, being clandestine or wanted to commit some crime or other. But I think that there was just this general sense that this was part of their rights, and they expected it. And if you read the founders, they're pretty well unanimous on it. I have not seen one piece of evidence that they either thought that this was only a collective right or that there was no such right for individuals. They over and over again say that this is, part of their rights as Englishmen to be able to defend themselves and protect themselves, and that was one of the things that made our country exceptional. They admit that. They felt quite proud of that.
Well, there's a lot you could say, but I'll just give you a few examples. So it is often said that because they took out for the common defense, that implies they were thinking about an individual right. But that's a circular argument because it assumes that the only possibilities are common defense or individual defense. In fact, if you look at the debates in Congress, it makes much more sense to think common defense in a debate in Congress would have threatened people who were worried about using militias to put down slave rebellions or Shays Rebellion. Common defense in the sense of Congress is about the defense of the nation. So there's a federalism interpretation that's actually much more persuasive and there's much more evidence. In fact, they actually take out the word composed of the body of the people, which you don't hear as much about. And look, an 1820 case tells you, it's a basic principle of historical methodology. An 1820 case tells you a lot about what people in 1820 thought. It doesn't tell you anything about what people in 1688 thought. I mean, there's a sort of classic historical fallacy called the fallacy of presumptive continuity. I don't doubt that actually the right evolved and expanded. Those 18th century cases show that very clearly, but that's very different than saying that was the understanding in 1688. I mean, that's just not good historical methodology any way you look at it.
It is important, though, if you want to understand how Americans saw it at the time of the drafting of our Constitution.
Well, 1820 still doesn't help you with 1788 or 1791, particularly if it's in England. I mean, continuities of place and time, those are classic principles of historical research. And then you look at the case of the Recorder of London, that actually is the exact example I have in my paper that Joyce is using the exception to the rule to prove the rule. Of course, in the middle of the Gordon riots where there's days of civil unrest, one of the noted exceptions is you can arm yourself, and again, it's arm yourself suitable to your condition, so there's still the class thing. You can arm yourself to put down riots and rebellions. That is an exemption that goes all the way back in common law. So it doesn't really establish what Joyce says it establishes. It just establishes that there was an exception, and that exception certainly included people using arms to restore peace, the king's peace. Sir John Knight, Tim Harris has a great account of that. Joyce doesn't mention that they say that the case had better been brought under common law, that they would have actually gotten a better result prosecuting him under common law. Well, how could the judge of the King's Bench have said that if there wasn't a legal case against traveling armed? So again, selective quotation, taking things out of context, these are problems for historians.
Let's let Professor Malcolm respond, and then we'll take a few questions from the floor.
We're talking about the Statute of Northampton. And under the Statute of Northampton, which is what the king was trying to use, there was nothing in common law that would have disarmed him. This attempt to use the Statute of Northampton to say that he should not go about armed, because not just going about armed, but armed because he was terrorizing people, that didn't fly. Even that didn't fly. So the king had no way of, under common law, disarming his opponents. And this was one way that he was trying to do it, and it failed. But anyway, I'd be happy to answer.
A couple questions from the floor. Joseph?
I have a quick question for Joyce, and this is not about historical methodology, in which I have nothing to contribute, but more about just what the lessons are we should draw from the history that you present. So to relate back to, as you usefully did, the theme of the conference and the sort of takeaway of the paper about the extension, the strength and scope of the right outside the home, let's say. And as I see it, there's sort of three possibilities, at least, that we could imagine. One is there's a right inside the home and not outside. There's the right inside the home and they are of equal strength. that is resistant to regulation in the same way. And then there's the middle position, which is the right is at its apex in the home. There's more room for public regulation sort of outside the home once you move into the public space, which I think are different. And that seems to me to come up, that sort of division, that middle position, in a lot of the sources, like the Dalton, who you both said, this is just for the part that you quoted, if thieves shall come to a man's house to rob him, really, he may lawful to defend his house. And that makes perfect sense because, and again, Blackstone and Is that where you are then? The middle position, that the right exists outside the home, but it's subject to more regulation? Because I see courts in kind of all three of these camps. And
that's interesting the way that you presented it. The court said that the right was most acute in the home, but it also said that there was a right to bear. So you had a right to carry for your self-defense. And so when you get to self-defense, I think it's hard to say, well, it can be regulated. Self-defense is already, in a sense, regulated under law. But I think that it really is an important aspect of the right. I don't think that you can just simply say secondary to the major Second Amendment right, because they added it in. And it certainly, as Thomas said, wasn't a question of bearing your gun from your kitchen to your bedroom. It was a question of being able to protect yourself. And the idea of self-defense is actually the most basic core right. I didn't have all the quotations from John Locke and Blackstone about it, but there's a strong sense that in your hour of need, there's nobody else there. You have to be able to protect yourself, and that you have a individual personal right. And that is helping to keep the king's peace. But that, it's an interesting approach to that question.
Greg?
I have related questions for Judd and Joyce. So for Judd, it seems like one way to I'm sure, oversimplify the argument you're making is that there is an impossibility or a great difficulty of translation from the conception of rights that exist at the time of the founding to the conception of rights that the Supreme Court is talking about, for example, in Heller. So it made me think about Amar, and you all know this better than I do, but Amar has this argument where basically, okay, the Second Amendment and other rights in the Bill of Rights had substantive meanings that were such at the time of the founding, and then the 14th Amendment acts, in his view, as a sort of means of translation or transition that alters the meaning of those rights. I'm curious whether you think that the 14th Amendment or anything else in subsequent history serves, sort of assists in that kind of process of translation along the lines you're talking about. Like does the 14th Amendment in any way help to convert this complex, politically embedded conception of rights into something that can legitimately be enforced as a sort of positivist right that the court's talking about now? And the sort of related or parallel question for Joyce, I'm curious what you do with Judd's sort of critique of the kind of extension of 18th century rights talk into the 20th and 21st century, that he's basically saying, yeah, sure, a lot of people in England, a lot of people in the colonial era in the United States would have said that the people have a right to X, Y, and Z, but that doesn't mean what right in the sense that the court is talking about in Heller.
Yeah, so the quick answer is it could, but from a historical standpoint, I'm very skeptical that it does. So the most likely place that this would happen is through the Privileges or Immunities Clause of the 14th Amendment, which recognizes rights of citizenship. Of course, rights of citizenship here are coterminous with the rights recognized in the social contract. That's literally what rights of citizenship are. The 14th Amendment is recognizing those rights that exist, but doesn't create the rights themselves. It doesn't change their status, but it provides an additional means of federal enforcement that was previously lacking. And so the way that people like John Bingham are talking about rights of citizenship in 1866 when they're debating this is that these are rights that already limit state governments. Now we're going to provide a means of federal enforcement for those rights. But under cases like Corfield and other early cases interpreting the Privileges and Immunities Clause of Article 4, there's a recognition that states have regulatory authority with respect to those rights that aren't delineated positive rights. And so cases like Corfield recognize different, even though every state has to provide citizens with the right of property, states can define what your rights of property are in different ways. And so that sort of general police powers jurisprudence survives the 14th Amendment, even on the account of the slaughterhouse dissenters. So you recognize that Justice Field in dissent, Justice Bradley in dissent, Justice Swain in dissent, all of them recognize general police powers to promote the public good with respect to limitations of natural liberty.
Joyce?
Yeah, I'd like to answer your question to Judd, if you don't mind. I'm really glad that you brought up the 14th Amendment. It's really important, and it says a lot about the attitude toward the Second Amendment. I mean, before the Civil War, when you had the Dred Scott opinion, Taney said that if the blacks were citizens, they could keep and carry guns wherever they went. Actually says that in that case. And one of the reasons, one of the strong motives for those amendments after the Civil War was that these recently freed enslaved people were not being allowed to carry their firearms. And they weren't allowed to have them, they weren't allowed to use them, and it was one of their rights as citizens now. So, the civil war really kind of outlines those difficulties of being outside of a right like that other people could prey on you, that you weren't able to defend yourself, and now you were supposed to get all the same rights as everybody else. So it was a good question. If you want to try me with yours, that was the one that was meant for me.
I guess, so that gets a lot of the way there, but I guess then the follow-on is, how do you get from that point to judicial enforceability against the power of the legislature in the sweeping sense that we now associate with constitutional rights?
Well, we'd like to think that, as Jefferson said, that they were inalienable, that the passage of 250 years is not going to, have these basic rights vanish. We don't want the right to, freedom of speech to vanish, or the press, or all, I think that it's still really essential. And I think that because the core of the Second Amendment is self-defense, there's nothing more essential to me than that. We still don't have, despite our police and our army, anyone who's there to protect us every day, all day. We really still need that personal right of self-defense.
With your forbearance, I'm going to ask one question in this lightning round, right? Because I think I'd be remiss. Without when there's a panel of people that are either steeped in history or actual historians, trained historians. Not to mention the new corpus linguistics database, the work of people like Neil Goldfarb or Dennis Barron, who have been sort of mining these 18th century documents. And when they mine them, what they come up with is that the term bear arms is not actually used in an individual sense. It's typically used in a collective military sense. And so one of the questions I have is, like, if that's true, and I'm not a good enough sort of empiricist to know if that conclusion, which I don't think has been rebutted yet, is true about the usage of the term bear arms in the 18th century, what is the entry point for the kind of history, the kind of social history, political history that everybody in this panel sort of works with?
Well, actually, Scalia rebutted that idea in Heller about it only talking about bearing arms only being exclusively in a military context. What I was going to say is that before Heller, the people who felt there was no individual right used to talk about the bear arms clause, because keep was so awkward. Keep meant somebody actually had it in their home. After Heller, the bear arms clause vanished. Keep is okay, and there's no bear. But actually, Scalia goes into this idea and actually looks up every place that he can find bear arms, as an analysis to show that it isn't exclusively and only used in military context. And there were founders who talked about bearing arms around their estates or whatever. So, but it is something that had come up, and of course, the dissent uses that. Everything that they saw in the Second Amendment, every bit of the language, to them was exclusively a military context, and that's part of it.
I hate to be a stickler for chronology again, but since the Corpus Linguistics was published after Scalia died, I don't know that one could actually argue that he rebutted it. The whole point of the Corpus Linguistics is it got beyond the very impressionistic use of evidence that Scalia did. In fact, if you follow the footnote trail, it turns out that he referenced an article by Clayton Kramer, gun rights activist, that was published in the Georgetown Journal of Law and Public Policy, which sounds very, very high-powered, but I looked it up, and it was the 570th best law review in America at the time. Of course, out of like 1,500 law reviews. Now, if we think about like, what does it mean to make an argument from authority, I'm putting 570th best law review not as a really great source. And what the corpus linguistics evidence shows is that they were just wrong. You know, they use English text interchangeably with American text. The most recent evidence shows that out of like 1,000 uses, 900 were unambiguously military. 99 of the remaining 100 are, you know, judgment calls. And the only unambiguous use was the translation of a French text talking about orangutans throwing stones as a form of bearing arms against their enemies. So not to make a monkey out of Heller, but literally their best evidence is the monkey example. And I'm pretty sure that wasn't on their minds when they were drafting the Second Amendment. So the corpus linguistic stuff is damning, but you haven't heard the leading originalists own up to it. That's kind of disappointing intellectually. And then if you think about the rule on preambles, which of course Eugene Volok's arguments about preamble was totally shredded by David Koenig at the time. And you know, instead of going to 19th century treatises, Scalia might have actually gone to John Jay, who might be a more relevant source. And Jay actually issues an opinion on the meaning of preambles from the 1790s. And he says, in the case of two possible constructions, the preamble is the tiebreaker. So do we go to 19th century treatises that Scalia probably did, that the founders didn't have access to? Or do we go to the author of the Federalist and the first Chief Justice, who said that, if it's any doubt, if there's even one counterexample, the preamble is the tiebreaker. And we know that there's the orangutan example, and then there's the other 900 examples.
Okay.
So even using the preamble, it's clear Heller is just completely wrong.
So I would
should have been on the court.
I would say that the type of evidence you're talking about would be highly relevant to delineating what the relevant tradition is that might define the positive right. But I would strongly resist any suggestion that there's no natural right outside of the home. There is. The problem here is that defining what that means in terms of limits on governmental power requires, as Greg suggests, some task of translating a rights framework that we no longer believe in into a modern positivist, judicially managed rights project that began in the middle 20th century. And so as a historian, I can't tell you how we're supposed to do that, but I think that is the sort of fundamental reason why we're having this debate in a very different way than it would have played out 200 years ago.
And with that, drinks are available.
Thank you.
Are you going over to drinks?
Yeah, I think just definitely one or two.
All right.
Oh, it is. There we go.